Okay, so good afternoon. I would like to welcome you back to this conference on corporate environmental responsibility. My name is Francisco Mendes Correia, and I'm a teacher at the University of Lisbon School of Law, and I will be chairing this first afternoon session. We have a very interesting session ahead on financial law and sustainable finance, so I would suggest we should start right away. We'll have an initial 20-minute presentation on sustainable finance by Dr. Diogo Bordeira Neves, which will be followed by a comment by Professor Mafalda Miranda Barbosa. And after that, there will be time for questions and answers or comments from the public. I would like to take this opportunity to warmly greet Professor Mafalda Miranda Barbosa from University of Coimbra School of Law, who joined us remotely, and thank her and Dr. Diogo Bordeira Neves from University of Lisbon School of Law for accepting this invitation to participate. After this topic on sustainable finance, presentations focusing on financial law will follow from a public and private law perspective by Dr. Joana Gama Gomes and Dr. Chen Chen, both from our own University of Lisbon School of Law. This will also be followed by a comment by Dr. Antonio Garcia Rol and from debate with the audience. I would like to thank again these distinguished speakers for sharing with us your views and knowledge on such an interesting and cutting-edge topic. I'm sure everyone is looking forward to hearing from you today. So without further ado, I give the floor to Dr. Diogo Bordeira Neves for his initial presentation on sustainable finance.
Thank you very much. I will start by thanking the organization, and specifically Professors Eloisa, Shen Shen, Professor Milena Pestrel. I would extend my regards to the moderator, Professor Mendes Correia, and to Professor Mafalda Miranda Barbosa, who is watching us virtually. I think we can skip to the next slide, please. I will start by delimiting the subject. I will focus, and as the theme is a bit broad, I will focus mainly on sustainable finance products from a general private law perspective, although I may touch on some regulatory points. I will try not to overlap the discussion following on the next panel, which I understand will focus mainly on SFDR and taxonomy, at least from a direct perspective. I would start by mentioning the major distinction, which is between sustainable finance products, in particularly loans and bonds. Lending may take many forms, but I will focus mainly on loans, empréstimos mútuos, and bonds, emissões de obrigações. The classification as sustainable as regards to these two sorts of products entails three possibilities: environmental purposes, green; social purposes, social; and a combination of the above, sustainable. The distinction between sustainable instruments versus sustainability-linked instruments is, I understand, as it follows. The sustainable instruments are mainly project-driven. This means that they finance certain projects, activities. We understand here that this is sort of a use of proceeds lending, ends-orienting, veja o escopo finalístico. And the distinction from the sustainability-linked instruments is that they are company-driven. They finance a particular company, encouraging sustainability, so they are on more general purposes lending and not use of proceeds lending. We will consider the highest market standards in both types of products, as they are the best international practices. But in some cases, namely when we are discussing small and medium enterprises, some of the standards that are being advanced by the industry may not be applicable. And this is of particular importance when we are dealing with the Portuguese scenario, where there are a lot of SMEs and not so much of bigger companies. For example, $1 million purpose loan by an SME to finance a piece of equipment that is much more energy efficient than an old one. Achieving the purpose of the loan is almost instantaneously and can be measured on the basis of the invoice for a piece of equipment delivered with a corresponding technical specification. So most of the standards that we will analyze here will not be applicable to SMEs. I will start with a brief introduction when it comes to sustainable instruments. These are instruments that finance a borrower or a issuer, when we are speaking about bonds, to carry out certain projects or activities. For example, in the case of green bonds issued by a bank, financing by a bank to carry out green projects, which are or maybe environmental, social, or if they correspond to the two characteristics highlighted, they will be sustainable if they combine both. They should only be categorized as sustainable when both the environmental and social aspects are primarily relevant. If one is only ancillary, then it should not be relevant for this purpose. The actual use of proceeds is decisive. They cannot be used for general corporate purposes lending, as sustainable is only measured here by a specific project or activity. And this can be in terms of financing or refinancing. In terms of distinctive traits of sustainable instruments, I have highlighted 6. These are not exclusive and these are merely indicative. I would say that the first one is the most relevant, and it relates to the use of proceeds. The use of proceeds for green, social, or sustainable projects must be duly described in the contractual documentation. For instance, they should be clear, they should be measurable, they should be quantifiable, and they should be reportable. These may only refer to certain lines or tranches within the framework or to a larger financing. They can also be measured by a bond-by-bond basis or on a portfolio or aggregated basis as applicable and agreed upon. The borrower or issuer may not have or may not currently have some projects, but it expects to have them in the future as long as the investors are properly informed. This should not prevent the instrument from being used and from being qualified as sustainable, with the funds being temporarily allocated in a certain way. The use of proceeds is a critical area in any loan, and even more so in these. It's about the purpose for which the funds will be used. In social instruments, for example, the purpose also includes identifying a relevant target audience, for example, disadvantaged groups. Attention should be taken to define what happens in this clause, or if the use of proceeds is not met, or if the project is no longer qualified as sustainable. For example, this can lead to an early repayment, which can then lead to an event of default, which can then lead to cross default, and to the exclusion of certain projects and to the exclusion of the company itself. As regards the second distinctive trait, the project evaluation and selection process, this will be essentially dealing with informing the borrower or the borrower or the issuer informing the investors about its environmental, social, and sustainability objectives and how the projects fit into the company's overall sustainability policy, the eligibility criteria for the projects to be financed, including any exclusion criteria, how it identifies and manages possible risks for other environmental or social issues, to understand the trade-off with the benefits to be achieved. For example, to understand the trade-off of solar, or that a specific energy project that involves the deforestation of a large area. If the financing projects or financing of financed no longer fulfill the criteria, it can no longer be qualified as environmental, social, and sustainable. The company should no longer treat the financing as such, and we can highlight here the possibility of converting a sustainable loan into a so-called normal loan, and this should be also contractual foreseen. As regards the third distinctive trait, the segregation and allocation of funds, funds should be deposited or in a dedicated account or otherwise segregated. And it is also recommended that the borrowers have an appropriate internal governance structure to manage these funds and to allocate them to the highlighted projects. Again, this should also be reflected in the contractual documentation. On the fourth place, reporting. Companies should or must report current information that allows the use of proceeds to be monitored at least annually until the allocation is complete and whenever there are material changes. The reporting should include a list of projects funded and amounts allocated, which may be more generic or aggregated without fully individualized detail in the light of confidentiality requirements, or if we are dealing with a large number of projects. For example, a green bond issued by a bank to finance a large number of green loans to its clients, I would say that reporting requirements should be taken into more general basis and not individually considered. It is recommended that information be provided on the impacts of the projects. This is recommended, but it is also mandatory under the climate bond standard through quantitative standards or indicators. For example, volume of emission reductions, percentage improvement in energy efficiency, increase in a number of beds in the hospital that is funded, and also stating the methodology that is used and the assumptions that are being used. Again, this should also be highlighted in the contractual documentation. As regards to monitoring, where appropriate, an external review by an independent third party should be obtained prior to the conclusion of the financing, the so-called second party opinion, and or periodically. This may be the auditor himself, who checks retrospectively, the auditor of the company, and the so-called second party opinion may be highlighted as a condition precedent to the financing to occur, or to certain reimbursements to occur. If a borrower has sufficient and credible in-house expertise, it could alternatively validate this matter and not require a second party opinion, thus reducing certain costs associated with the emission of a second party opinion. As regards to framework, what is a framework? Framework is a document from the issuer or borrower scheduling the debt issue in concern of its program, explaining the terms of compliance with the above requirements, and made available to the investor, of course. It should be subject also to an independent review by an external third party, and is also highly recommended under the International Capital Markets Association standards. The structure of for example, a green bond framework could be modeled on the following: first, an introduction, then the framework itself, which will describe the rationale for establishing the framework, describe the alignment of the issuer's green bond or green bond program with the four components of the green bond, the information and possible engagement with external review providers, and that's it. When it comes now to, and we have highlighted all of the traits in regards to sustainable instruments, I will focus more, and I think in a market like Portugal, the second types of products will be of a more essential dimension, which are sustainability linked instruments and not sustainable. Now, when it comes to sustainability linked instruments, we are talking about instruments that finance the borrower issuer, incentivizing them to substantially or in an ambitious manner to improve their sustainable performance through pre-established and verifiable indicators. The actual use of the funds made available is not decisive. So the use of proceeds is not decisible. They can be used for general corporate purposes, because substantially in these cases, it is not measured by a particular project or activity. This will be of the more essential nature. For example, in a scenario of default, for example, sustainable instruments default will be analyzed almost always as regards the project itself, and when regards to sustainable linked instruments, these will be measured as regards to certain indicators that I will now explain. The first type of these indicators are KPIs or key performance indicators. They must be credible key KPIs with relevant rationales and motivation, effectively relevant and strategic to the company's business in future. They should be clearly measurable, quantifiable, based on methodology and comparable against one or more parameters or benchmarks. These aspects should also be defined in the contractual documentation. The second type of indicators are SPTs, or sustainable performance targets. It must fit into the company's general sustainability policy. They should be adequately calibrated as they establish the contractual level of ambition for the issuer borrower to improve. They must be relevant throughout the life of the loan. Attention, so that they are not KPIs or STPs that cease to be material before the maturity of the loan. And they should also be leveled as in terms of material progression. This means that they can't be business as usual. The level of ambition must be higher than what was historically has been the case for a company. For example, in that regards the 3 previous years, or has already been publicly announced by the borrower, or to which the borrower has already been committed. This should be defined in percentages or in absolute value as appropriate. There may be or not a sustainable coordinator or agent to negotiate the KPIs and SPTs with the borrower. But this, I would say that this sustainable coordinator or agent is not supposed to be fiduciarily accountable to the investors, who should take a critical view of the issue. They should take a critical view of the product itself, and they should contribute to the sense and level of ambition of the STPs. It is recommended to issue a second party opinion at the time of the financing is signed. This may be qualified as a CP to the financing. Especially in the case of longer maturities, it may be advisable to provide for situations in which these KPIs or SPTs are adjusted. For example, in M&A transactions with the potential to alter the status of a relevant company, both on the buyer side and on the seller side. In these situations, the parties should negotiate changes in good faith and possibly switch to a normal loan regime if no agreement is reached. And I see no obstacle to a conversion of the loan, at least from a general private law point of view. As regards to specific contractual features of sustainability-linked products, sustainability-linked products tend to increase the sustainable footprint of companies over time. Therefore, contractual terms must allocate different economic consequences depending on the evolution of the company's performance. This will be met, for example, in the spread, in the amortization plan, in future disbursements, on the flexibility of certain financial covenants. The most common situation is changes to the interest rate or spread, a reduction in relation to the base value if the increased threshold is reached, or the rise back to the base value, or increase in relation to the base value. It's called the two-way. In order to maintain a trend of continuous improvements, the tendency is towards a dynamic approach. But a critical remark should be made. Lenders tend to benefit from the borrower's poorer ESG perspective. One possibility to counter this criticism is for the differential or part of it, the difference between the value and the base value, to be donated by the company for ESG purposes, or set aside in a dedicated, segregated ESG account to improve the company and applied for this structure. Typically, failure to meet these improvement thresholds does not give rise to an event of default, but rather to this type of economic consequence, to the upper of the base value in regards to the value itself. Whilst reporting, companies must annually report information that they deem to be essential. For example, they should prepare a periodic sustainability report. And as regards to monitoring, now I'm speeding up, as you can see. In line with the above, publication of monitoring should be favorable if feasible. The company's report and the verification report are the necessary elements for investors to analyze whether the issue borrower has actually reached an agreement on improvement results. I think I'm out of time. I tried to provide as much information as I could, and now I would give the floor to the moderator, Professor Mendes-Correia. Thank you.
Thank you. Thank you very much, Dr. Diogo Bordeira Neves, for your excellent presentation and for complying with the time limits. And now, without further delay, I would hand the floor to Professor Mafalda Miranda Barbosa, who will join us remotely.
Thank you very much. I'm very pleased to meet Professor Francisco Mendes-Correia, even remotely, and it's an honor to participate in a session moderated by you, Professor. I would also like to thank Professor Madalena Terceiro de Oliveira for the invitation to speak at this Congress and to greet the other speakers as well as everyone present in the event. Finally, I would like to pay my compliments to Professor Diogo Neves, who offered us an excellent communication. And I have to say that my task here has been much more easier due to the excellence of his work. So I can limit myself to making a few basic observations about this topic. I think, firstly, it's important to underline that financial markets have been incorporating sustainability factors, and this phenomenon seems inevitable. Nowadays, players show that they are concerned with combating environmental and social problems, apart from the concern to maximize profits. So this should be applauded, especially because financial markets are globally one of Europe's strong sectors, one of our new winning industries. But on the other hand, it is undeniable that considering sustainability factors at the level of financial products entails additional risks. And if we take into consideration the important distinction between bonds marketed as environmentally sustainable and bonds linked to sustainability, then we must consider that in addition to the traditional credit and market risks, there is the risk of non-compliance with the green project or the social project being financed or used as collateral for the bond, or even the risk of poor environmental performance of the project. And this means that besides the issue of greenwashing, which can be faced by imposing disclosure duties, there are specific legal issues arising after the issuance and after the subscription of the bond or after the loan celebration. So I think we have to take into consideration two different moments. First, the moment previous to the celebration of the contract in the basis of the financial instrument. And at this period, any potential breach of information duties can lead to the invalidity of the contract by error or deceit. And in this context, it assumes special relevance, the duties imposed by green bonds regulation, but also the duties imposed by regulation EU 2019-2088 of the European Parliament and the Council, amended by regulation EU 2020-852 of the European Parliament and the Council, related to the disclosure of sustainability-related information. But these have different consequences, because by reinforcing these information duties, of course, an environment of increased confidence is created, allowing for increased capital flows into environmentally sustainable projects. But at the same time, rights of investors are strained, enabling them to invoke these rules to demand compensation in case of misinformation. And at this level, mistake or deceit regimes may come into play, depending on the circumstances of the case and the specific problematic structure in question. In a necessarily simplified manner, I can say that the investor's decision to invest may have been influenced by a particular environmental or social concern. So an incorrect representation of the reality regarding the positive environmental or social impact of this investment, or the absence of a negative social, human, or environmental impact, can be considered as a relevant mistake. And if such mistake is essential and concerns a circumstance that both parties regard it as an essential condition to the contract, such that it may have even determined a different return on investment and a different interest rate on the bond. So the bond subscription can be annulled under Article 252, number 2 of the Portuguese Civil Code. And if the financial return depends on the success of the sustainable project underlying the investment, as in the case of impact investment, then the error is an error regarding the object, leading to the annullability of the transaction under Article 251 and 247 of the Portuguese Civil Code. And in a third case, in the case of an inaccurate representation of the green qualities of the issue, the mistake may rest on the recipient, and the regime of the Article 247 of the Civil Code is also applicable by reference to Article 251. I think it's important to say that essentiality is crucial here. However, although the dependence between the investment and the green or social or human goals, it's absolute, I don't believe that essentiality can be presumed. The error regime establishes it as a requirement of relevance from a subjective point of view. So I think it must be proven, although, of course, we can say that proving it won't be difficult because of that dependence. Then when there is a deliberate omission of information that must be provided, that can potentially constitute a case of omissive fraud, deceit. This will be a fraud by the part of the recipient. In the case of the acquisition of the bond or other securities in the primary market, depending, of course, on the subscription scheme. And in this context, we can say that the negligent omission of information that is required by law can be equivalent for the relevant purpose to deceit. And in the case of omission of information by the broker, the terms of the problem have to be considered in other way. So we have also to take into consideration a second moment, the moment after the subscription or the celebration of the transaction. And in that moment, the problems are different. If achieving the environmentally sustainable project is on the basis of the transaction and conditions of the structure of the main obligation undertaken, then any change in the use of the borrowed capital is bound to affect the core essence of the transaction, with obvious consequences on the sustainability of the main obligations. In a way, I can say that we can apply here the regime of supervening change in circumstances. So, in the case of an obligation where the financial return depends on the success of the environmentally sustainable project it aims to finance, and in the case of fault, then any change in the use of the borrowed capital implies a breach in the main obligation itself, with a necessary impact on contract resolution. And this allows us to grasp an essential fact. No matter how new these issues are, and no matter how these issues are subject to regulation at the European level, a comprehensive understanding of the problems requires a framework with the civil law and further within the global juridical order. And it raises the question, can the consumer protection rules be invoked, considering that in certain cases, the investor can be qualified as a consumer? So I think in this perspective, there are important proposals of directives that are relevant. So I leave this question for reflection, especially taking into consideration the importance of consumer related to financial services. Thank you very much.
Thank you very much, Professor Mafalda Miranda Barbosa. You have given us plenty of food for thought, and with that suggestion of returning to the basic civil law principles, which is also always welcome. Now I would ask the public if there are any questions, comments, someone who would like to share your views on these very interesting topics of sustainable finance. Of course.
First of all, thank you for Diogo and Professor Mafalda for So my compliments on the main conference and then on the commentary. I think the questions regarding invalidity and in its impact in the issue, and for once I will focus on the distinction that Diogo drew between sustainable finance and sustainable linked instruments. And my question is, in this case, will there be any room for invalidity, or we will just be complying with the contractual framework? And so perhaps questions on error and invalidity will mostly be used on green bonds and sustainable financial instruments, and not sustainably linked instruments. So that is basically my question. Thank you.
Let me start by thanking Professor Miranda Barbosa for her comments and answering Professor Paul Camera's question. I would say that I do tend to agree when it comes to analyzing error, and when it comes to sustainably linked instruments, the space for analysis will be quite reduced in comparison to sustainable instruments. In practice, from the contractual frameworks that I have worked with and that I have seen in other jurisdictions, which are more sophisticated than the Portuguese one, at least at the moment, when it comes to these issuances, the consequence will be almost always an economic consequence when it comes to reduction or increase of the spread or consequences in terms of financial covenances and amortization, or some early repayment, but not all. In comparison, when it comes to sustainable instruments, the consequence will be default. If the project no longer meets the characteristics that were essential, that were recognized as essential in signing the agreement, when it comes to sustainable instruments, the consequence will be most always default. In comparison, when we are speaking about sustainable linked instruments, the consequence will be economic. And I would say this is due to the fact that the decision to contract is not in light of a specific use of proceeds, it's in light of the general economic condition of a company. And this is not different from the normal bond issuances that we have been issuing in the market. Alas, for quite a few decades now, we have seen the inclusion of certain characteristics that are now called ESG, but that they have always been present in certain fields in regards to certain industries. For example, in the energy sector, or in some transportation sectors, such as aviation, such as shipping. But yes, with regards to answering your question, in regards to sustainable linked instruments, I would say that the space for analysis of invalidity will be quite reduced. Yes.
Any more questions, comments from the public?
I would just like to highlight one of the affirmations that Professor Miranda Barbosa highlighted, with which I tend to agree, and it has to do with the essentiality and recognition of the essentiality of ESG traits in certain loans. I would go further and I would say that insofar as an investor has nowadays a multitude of products that it can invest with, it goes to its, for example, a consumer even, it goes to its bank manager, and it has a multitude of financial products in which it can invest. If some of those financial products are sustainable, and if some of those financial products are sustainably linked, I would say that I would go further, and I would say that we can automatically verify the presumption that it was essential, and it was recognized that it was essential in the will to hire that certain financial product, that product corresponded to the ESG traits that were advanced. So I would say that in which regards the burden of proof, that the investor will have an easy job when it comes to prove that those characteristics were essential in its will to hire, insofar as if they weren't, he would have chosen, or she would have chosen a different product without those ESG traits. So I would say that this is extremely relevant when it comes to the formation of the will to hire.
Well, if no one has a question, I have one for Dr. Diogo Bordeira Neves and for Professor Mafalda Miranda Barbosa. I was wondering, when hearing you, if the development of sustainable finance products will not entail a new chapter on the liability of third parties in what concerns loans and bonds, but especially loans, because the outcome of a loan with the very heavy consequences of non-compliance and with the resolution may depend on a certain determination by a third party, a certain an auditing report, an evaluation report from a third party, and the third party is not necessarily contracted or linked by a contract with the financed party. So aren't we on the verge of another chapter of third party liability in financial law?
I'm not sure if Professor Miranda Barbosa wants to take the stand first, or if I can answer first.
I can answer first. I don't know.
Please go ahead.
Thank you very much. I think the responsibility of third parties is not affected to the extent that this liability already exists. We can think about contracts with protective effectiveness for third parties, and on special regimes as liability of the broker for the prospect, for example. But of course, we are here dealing with a topic that can enable the liability of third parties that is very important.
I tend to agree. I would only add the following. When it comes to the hiring, which is not mandatory unless in certain circumstances, the hiring of a sustainability coordinator or agent to negotiate KPIs and SPTs, in most cases, he will not be fiduciarily responsible. What he says is that those KPIs or those SPTs, if fulfilled by the borrower or issuer, will be adequate to obtain such a result. This is what he says. He does not guarantee that when it comes to sustainable instruments, that a project will be, during the full maturity of the loan, be adequate to be sustainable, and it does not guarantee a certain financial position of the company. In this case, I would say that the responsible in third-party terms of the sustainability coordinator or agent will be most likely similar to responsibility of a supervisory board. Insofar as, and when we are dealing with listed companies, which have in-house environmental teams dedicated to the producement of ESG reports, they will not need, they won't need to hire a sustainability coordinator. So this responsibility will be, I would say, parallel. With the exception when a second party opinion is issued. But the second party opinion is issued as to reference to a certain time period. This is why it's normally issued as a CP to the signing. The second party opinion does not guarantee, alas, that the loan will be fulfilled, that the condition of the loan will be fulfilled, that the project will be adequate to be sustainable throughout the maturity of the loan. The second party opinion references to a certain temporal timeline. From an investor's perspective, what can we demand in order to reduce this risk? We can demand that not only a second party opinion is issued, or that one is issued regularly. For example, in an annual capacity, in order to monitor, at least from an annual point of view, that the conditions of the loan are being actually fulfilled. But apart from that, I tend to agree with Professor Miranda Barbosa.
Okay, thank you very much. Thank you very much, Professor Mafalda Miranda Barbosa. I think now we are just in time to move to financial law and the EU regulations on financial disclosure and taxonomy. So I would welcome to the table Dr. Joana Gama Gomes and Dr. Chen Chen.
Isso é seu ou é do Diogo? Do Diogo? Ah, não tem. Então, eu posso ficar com o do Diogo.
So I don't know if you have sorted the order.
Can start.
Okay, so Dr. Joana Gama Gomes, the floor is yours.
Okay, thank you. So thank you for inviting us to be here. Thank you to Professor Luis Oliveira, Professor Madalena Prestrel de Oliveira, and to my colleague Chen for writing this with me. So following on the global objectives established in the Paris Agreement and also in the European Green Deal, the EU has acknowledged that financial systems can also play a role in reaching environmental goals and in the fight against climate change. It can be, and they can be part of the solution towards a more sustainable and greener economy. And so, as a result, the EU has adopted several pieces of legislation, as well as other non-legal acts, to regulate the inclusion of sustainability considerations in investment made and also in financial products. In our chapter, we have focused on two specific pieces of legislation. We focused on the taxonomy regulation and also on the sustainable finance disclosure regulation, the CFDR. These have introduced fundamental changes to the European financial system by establishing unified classification systems, and we'll see further what that means. So this started, you have our table of contents there. This started in 2018 after the adoption of the Paris Agreement. And so the EU Commission started by establishing in 2016 and then following up in 2018, a high-level expert group on sustainable finance to develop sort of a roadmap for what the EU could do in terms of inserting sustainability considerations in investments and financial products. And so the high-level experts group on sustainable finance in 2018 offered a comprehensive view towards a financial sector that could support EU goals on sustainability and a greener economy. And one of the priorities was to establish a common sustainability taxonomy at the EU level to define areas where investments are needed most, and to fight what has been called greenwashing in terms of establishing defined criteria and uniform harmonized criteria for what is considered sustainable investment. So in June 2020, the taxonomy regulation was adopted, and this far there have been other pieces of legislation such as the CFDR. Now, more recently, we have had the Taxonomy Climate Delegated Act, and also the proposal for a corporate sustainability reporting directive. And even in 2023, we see new proposals by the Commission, also adding new information to the taxonomy regulation by delegated acts. So, as I said before, the taxonomy regulation followed the need to establish a unified classification system for sustainable activities in the EU internal market. It was adopted on the basis of Article 114 of the TFEU. It was the need for a unified classification system for sustainable activities that resulted so in the adoption of the taxonomy regulation. So now going back to the taxonomy, just to briefly give you an overview of the scope of the taxonomy regulation. Also, what is an environmentally sustainable activity, which is the major definition of the taxonomy regulation. Then some disclosure obligations that are in the regulation, and then to finish, some delegated and implementing acts that the Commission has been issuing also to complement the taxonomy regulation. So the purpose and the main purpose of the taxonomy regulation is to establish the criteria for determining whether an economic activity qualifies as environmentally sustainable, for the purpose of establishing the degree to which an investment is environmentally sustainable. The framework of the regulation applies to measures adopted by member states and also by the Union, setting out requirements for financial market participants or issuers. In respect of financial products, corporate bonds, also for financial market participants that make available financial products, and for undertakings which are subject to the obligation to publish a non-financial statement or a consolidated non-financial statement. So what qualifies as an environmentally sustainable activity? Article 3 of the taxonomy regulation clearly sets out what is an economic activity that qualifies as an environmental sustainable activity. So this is mainly where the activity contributes to one or more of the environmental objectives that are set out in the taxonomy regulation. And what are these environmental objectives that the regulation has chosen to be the most important ones? So climate change mitigation, climate change adaptation, the sustainable use and protection of water and marine resources, the transition to a circular economy, pollution prevention and control, and also the protection and restoration of biodiversity and ecosystems. So an economic activity is environmentally sustainable if it contributes to one of these objectives, of these purposes of the taxonomy regulation. The regulation, Article 17, details the conditions through which an economic activity, on the contrary, shall be considered to do harm to one of these objectives. And for this assessment, where an economic activity shall be considered to significantly harm one of the objectives, the assessment includes an assessment of the whole life cycle of the activity, and for example, the production, the use, and end of life of products and services. The taxonomy regulation concerning disclosure obligations also establishes certain transparency obligations for financial products related to pre-contractual disclosures, to periodic reports, and also to non-financial statements. Because the objectives remain quite open, the Commission has had to specify and further specify what these objectives means. And so it has issued several delegated and implemented acts. So far we have the Climate Delegated Act, the Disclosures Delegated Act, the Complementary Climate Delegated Act, and the Environmental Delegated Act. So all of these pieces of secondary legislation are there to specify what competent authorities and what market participants need to do to comply with the obligations laid down in the taxonomy regulation, and especially what the objectives that I said, the 6 environmental objectives that influence whether an economic activity is qualified as environmentally sustainable, what these objectives mean, and what companies need to comply in order to meet the criteria of the objectives.
We have additional 2 points that will not speak, and we can pass to, I think, the floor to Professor Mendes Correia, because this will all be in our chapter that will be released today, I think. No? In few days. So in few days. Professor, sorry.
Thank you very much for your efforts in complying with the time limits, and then maybe we'll have the opportunity to come back to those issues on the questions and answer time. Right now, I will hand the floor to Dr. Antonio Garcia Rolo, which will comment on this presentation on financial law and the EU recent legislation. Go ahead.
Well, first of all, thank you so much for having invited me. It's first of all, thank you to Professor Carla Mato Gomes, Professor Luís Oliveira, and Professor Madalena Posterior Oliveira, and also I'd like to greet my my panel colleagues over here. First of all, this was quite an enlightening presentation on the SFDR and the taxonomy regulation. This issue of environmental disclosure can be truly daunting and difficult to crack open for someone not really into the issue. But in my opinion, this take on the issue taken by Shan and by Joana Gama Gomes was perfect, and I'm pretty sure from what I've seen that this chapter will be an excellent way for someone who is not familiarized with this issue to get a clear-cut and straightforward picture of it. And indeed, the SFDR and the taxonomy regulation are part of a web of disclosure duties that are meant to foster indirect pressure by investors, essentially institutional investors, on market actors to adopt more sustainable practices. Besides the SFDR and the taxonomy regulation, let's not forget that we also have, as part of this European web of disclosure duties, we have articles 19A and 29A of the Accounting Directive, which are usually known separately as the Non-Financial Reporting Directive, or NFRD, which were overhauled earlier this year by what Joanna has already referred to, the Corporate Sustainability Reporting Directive. Additionally, last week we had the Green Bonds Regulation published, establishing a registration system and some more disclosure duties for the issuance of European green bonds as well. So even though all of these instruments are concerned with environmental disclosure, the SFDR seems to have a narrower scope of targets when compared with the NFRD, which applies to companies regardless of the sectors they're in. And so the SFDR disclosure duties are directed to inform investors and not consumers in the general public, which is natural considering its focus on the financial sector. And indeed, these mandatory disclosure duties seek to achieve changes in the actions of the relevant market players by encouraging active oversight by better informed and hopefully more active shareholders, stakeholders, and even the general public. Such pressure on management can be exercised by shareholders through their legal or statutory powers, or by stakeholders such as investors by their market decisions, through better informed decisions they can take, or even by the public at large through the fear of reputational effects of disclosing, let's say, unpleasant information. And so the underlying mechanism of this expected behavioral cycle is basically step one. Mandatory disclosure forces relevant companies to enhance the quality and the quantity of the information disclosed. Step two, the disclosure of information equips shareholders, stakeholders, and investors, and other stakeholders as well, employees, customers, suppliers, government authorities, and whatnot, the expected users of such information, with new information that can change your attitude towards the specific company and prompt them to take action or refrain from taking action that reflects this new information. And the disclosing companies might change, step three, they change their behavior either to preemptively respond to the action change by shareholders and stakeholders, or to react to that change ex post. This approach is different from the traditional corporate disclosure rules because it pursues concrete public policy objectives that do not only concern pricing in capital markets, but aim at shaping corporate behavior and its positive and negative externalities on shareholders and stakeholders, discouraging actions deemed undesirable by the legislator and encouraging actions deemed desirable by the legislator, being a somehow light-handed alternative to more direct intervention. Here in the SFDR and also in the NFRD, EU lawmakers assume that while shareholders and stakeholders might not initially crave that much for this kind of information, once it is made available, they can use it to measure corporate performance on these environmental metrics and even pressure management bodies to adopt a more proactive role in addressing them. This can also create an incentive for companies to behave, so basically through behavior deterrence, because it's been widely pointed out that if disclosure of such information was not mandatory, companies would not disclose this information voluntarily, as corporate insiders, such as management vis-à-vis shareholders or shareholders vis-à-vis third parties, usually prefer to suppress bad news or unpleasant information. After all, who wants to announce far and wide that their doubtful behaviors on environmental issues? And there seems to be some empirical evidence that suggests that mandatory disclosure works in these ways. So mandates to disclose environmental or even social information motivates companies to invest more environmentally and socially consciously in order to attract investors with such preferences. Two, the company's anticipation of social pressure and reputation concerns will make the relevant company careful when dealing with the issue it is concerned with. And three, disclosure reinforces managers' personal motives to act in line with shareholder, investor, or stakeholder preference. Therefore, this approach of mandatory disclosure duties is widely seen as a sensible balance between not doing anything at all and a more authoritarian and interventionist approach. However, there's also been, of course, some criticism of this approach, as any approach, of course. And usually this criticism can be divided into two main groups, either over policy or it can be more technical. On a policy level, one can question these basic assumptions of what I just said. So the idea of that we have this watchful institutional investor or public who will punish any misbehavior or on environmental issues. Some authors have pointed this as being overstated. And from a political point of view, mandatory disclosure and imposition of the burden to act proactively on companies can also be seen as a way for national governments or organizations such as the EU to avoid to act directly on the issue or to issue more in-depth or direct regulation. If companies themselves take care of this, why should I, the government, care? So it's funny because that criticism comes both from people who hold views would be hostile to this, to further burdens on companies, or people who hold the opposite views of saying this is not enough. So it can come from both sides of the aisle in that regard. And some even argue that some of these rules are nothing more than like state-backed greenwashing, because not only can simple disclosure incentivize companies to think they have done enough for the environment and not act any further, but even an act designed to prevent greenwashing, such as the taxonomy regulation, can still allow it in practice. For instance, let's say a product that it's 80% compliant and 20% uncompliant. Should it be considered, or could it be marketed as compliant? And there's also, of course, the fear of outsourcing by financial actors of their data. gathering and data assessment to sustainability rating agencies or service providers, so companies. Basically, this criticism would say that even though so despite this framework, companies still don't genuinely care about this, so they'll just outsource it to some third party who will take care of this for them and clean their conscience. So there's also that criticism. And finally, of course, the classic criticism of the high costs and burdens. Some authors point that such costs might even end up being incentives for companies to just sometimes, because might be so costly to disclose, that basically disclose, okay, my product is not sustainable, rather than going through the costly in-depth assessment of all activities. And some authors fear that that will make sustainable finance permanently a niche market, a costly niche product, very much like, I don't know, biological food is in retail markets. From a more technical point of view, of course, these acts have been criticized for an excessive ex-post focus that transformed the disclosure of environmental issues into a mere box-ticking exercise without bringing about genuine concerns in corporate boards, limited subjective scopes, and enforcement and inconsistencies between the acts themselves. So on this note of the potentially high costs of compliance, there's been some criticism, and with this I start my first question, there's been some criticism of the excessive complexity of the SFDR taxonomy regulation framework, because it's ripe with unclear definitions and shifting interpretations, which might contribute to the increase of the likelihood of non-compliance. Many authors and practitioners have pointed out that some of the most basic concepts are still very thinly defined, such as promotes in Article 8 of the SFDR, or the scope of disclosure obligations themselves, and the interpretation of sustainable investment in Article 217 of the SFDR. And even some European supervisory authorities themselves have also asked those questions to the Commission. So, in your opinion, is the complexity of this framework of rules a pressing issue? How is it being addressed in order to create some predictability in the market? And I asked Professor Mendes-Correia, maybe, I also have two further questions. I don't know if I should make all the questions now or if I should.
Well, I think that maybe let's hear from the authors of the chapter, and then you'll.
Okay. No, it's okay.
Yeah, on my side, just to note that this is exactly your question is exactly what the Commission has done with the delegated acts. The 4 delegated acts define technical criteria, which was not in the taxonomy regulation, to make it easier for the member states and then also for the companies regulated under the taxonomy regulation to understand what the objectives mean and what is expected of them.
If there are any further questions from the audience? Okay, so I would like to thank all the presentations and the comments and all the attention from the audience and the very interesting questions. And we will meet again at 4:30, isn't it? Coffee break outside. Thank you very much.
Thank you very much.